Are you taking up the offer, Ms. Giovanetti?
No, my lords, I'm not proposing to make any more submissions. I just wanted to mention exactly, we handed up the pages that I think my Lord Justice Peter Jackson said were missing from his supplementary bundle. We weren't clear whether the court had them or not.
Thank you.
That's the back of the
Supplementary bundle.
Thank you very much.
Very grateful to you. Mr. Butler.
Thank you, Lord. Can I give you the outline structure of my proposed submissions? 4 topics. First, on a plain reading, what do we say 15.37 provides? Second, we accept that on a plain reading, some victims do better than others under the policy. But I want to show, my lords, that it's not just people in the claimant's position. There are all sorts of anomalies that result from 15.37. Third, I propose to say a little bit about the correct approach to construing policies. And then fourth, I propose to address you on the context in which this policy was made, dealing with the contract and the FAQs.
Yes.
So the ordinary meaning of version 1, this is, I've got it in the supplementary authorities.
Yes.
Tab 1.
Yes.
So this is the version published on the 24th of March 2020. If we could look please at 15.36, so my copy, page 7.
You gave a reference I didn't catch, sorry.
It's supplementary authorities.
Yes, thank you.
Internal page 7.
Thank you.
So 15.36, within that paragraph, the victim's entitlement depends on the nature of his or her accommodation. If the victim is in other accommodation, third bullet, meaning not VCC accommodation, then under 15.36 the sum is £35 a week. And if one were to read 15.36 in isolation, that would govern the claimant's position.
Well, you mean that third bullet point, i.e. £35 a week?
Exactly.
Yes.
But that is, of course, subject to 15.37. That explains that the position is different if one received financial support under sections 95, 98, or 4 of the 1999 Act. And then second sentence of 15.37, in these circumstances, so in the circumstances of receiving financial support under 95, 98 or 4, then the victim will receive £65 a week, and that £65 is made up of asylum payments and a further VCC payments. And so we say the trigger for paragraph 15.37 is the receipt of section 4, 95 or 98 payments. The trigger isn't a particular subcategory of section 4, 95 or 98 payments. And the trigger isn't the form of accommodation. Now, given that 15.37 cross-refers to sections 4, 95 and 98, one can only understand the scope of the policy if one understands what those legislative provisions say in relation to financial support. So, if I may, I propose to say a little bit about those provisions.
Yes.
And if we could begin, please, with section 95. Ms. Giovanetti already showed you the text of 95. I'm not proposing to go back there. Save to recall that 95 doesn't say on its face how much somebody is to receive. And if we could also recall that 95 subsection 12 stated that Schedule 8 of the Act gives the Secretary of State the power to make regulations to put meat on the bones, as it were. And can I just show the court Schedule 8? We haven't looked at that yet. That's in the Supplementary Authorities Bundle, tab 2, page 10. Paragraph 3 of Schedule 8 provides for prescribing levels of support and for departing from the prescribed levels.
I'm sorry, it's regular paragraph.
Paragraph 3 of Schedule 8.
Thank you very much.
So 3A provides for prescribed levels, 3B provides for departing from the prescribed levels. And then that power, that regulation making power, is exercised to make Regulation 10. And if we could please pick up Regulation 10, that is in the main authorities bundle.
Sorry, just a minute. This is Regulation 10 of the
Regulation 10 of the Asylum Support Regulations,
yes.
Main Authorities Bundle, tab 2, page 44.
Yes.
Paragraph 1 refers to a decision that asylum support should be provided. Asylum support is a defined term in the regulations. I won't turn it up unless you want me to. Regulation 2 specifies that asylum support means Section 95 support. So Regulation 10 only relates to 95, it doesn't relate to Section 4 or Section 98. And then you've already looked at the text of paragraph 2 and paragraph 5, Regulation 10, paragraph 2 and paragraph 5. In my submission, the combined effect of paragraphs 2 and 5 is threefold. First, the general rule is that support comprises a set cash payment. My second point is that it's a general, not invariable rule. And my third point is that the 10.2 payment will be reduced if the asylum accommodation meets other essential living needs. That's what 10.5 says. I'll just make a point in passing at this stage. In practice, everyone who is accommodated in self-catered asylum accommodation, everyone has always been entitled to some cash support because the hotels have never met all of the assessed essential living needs. They've never provided clothing, they've never provided travel, and in the vast majority of cases haven't provided communications provision. And that's exactly why the Secretary of State recognised that there needed to be a cash payment to those in full board accommodation. And that was then supplemented by the judgment in JM where Mrs. Justice Farby said, actually, you've left out account communication needs. The point I just wanted to make in passing is that even those in full board accommodation have always been entitled to some cash.
So is this your response to the toothpaste argument?
Well,
That somebody can be, as it were, converted into a different total outcome simply by the provision of toothpaste. You're saying that the circumstances in which somebody will get nothing at all is not real world.
it's not real world under Section 95. I think in fairness to Ms Giovanetti, she was talking about Section 98. Because I think that the Secretary of State's position is that for a short-term period, before the Section 95 decision is taken, somebody could do without clothing, without travel, without communications. Now, what I'm going to come on to show you in a moment is that actually in practice, even under Section 98, many people did receive some cash payment. But at the moment, I'm just focusing on Section 95.
Thank you.
The point that I'm coming to in relation to Section 95 is that the Section 95 regime expressly contemplates that the amount of cash payment will vary depending on the form of accommodation provided. And so when paragraph 15.37 of the guidance refers to financial support under Section 95, it must be taken to contemplate that some people will receive financial support at less than the general sum. There's another feature of Section 95 payments that I wanted to show you. If we could please, if I could begin by going back to Schedule 8. So back to Supplementary Authorities, tab 2, page 10. And if we could this time please look at paragraph 5. This provides for the making of regulations to provide for the reduction of Section 95 support on account of income from other sources. That's then given effect in the regulations. So back, if I may, to Authority, tab 2, page 45. It's given effect by Regulation 12.
Sorry, just slow down a moment. Yes, Regulation 12.
So Regulation 12 on page 45, that duly provides for deductions to be made if the asylum seeker has income from another source. And so the effect of that is that if, for example...
It's not just income, it's also support.
Yes, it is. But I'm just for my example, I'm focusing on income. So if, for example, a charity provides an asylum seeker with £10 a week, then the Secretary of State must consider reducing the Section 95 sum. And the Secretary of State might, for example, decide to reduce the general sum of £40.85, currently £40.85, might decide to reduce that by the full £10 a week. That would be permitted by Regulation 12. And so I repeat the point that I made a few moments ago. When 15.37 of the policy refers to financial support under Section 95, it must be taken to contemplate that some people will receive less than the general sum on account of income from other sources. And then the final Section 95 permutation that I wanted to show you is by reference to Section 96. That's in tab 1 of the main authorities at page 14. And if I give you the punchline first and then explain how one gets there, the punchline is that Section 95 sum can be increased if there are exceptional circumstances, if the asylum seeker has exceptional circumstances. And the way one gets there is that 96 subsection 1A and B provide for accommodation and essential living needs. And then subsection 2, the Secretary of State can exceptionally provide support in other ways. Now that, I don't find that very clear on the face of the legislation, but it's explained in JM. And that's tab 20 of the main authorities bundle. At page 467. So main authorities, page 467. If I could ask my lords please to read paragraph 22.
Quoting Mr. Justice Popplewell.
Exactly. And so when paragraph 15.37 of the policy refers to financial support under Section 95, it must also be taken to contemplate that some people will receive more than the general sum under Section 95. And so the policy isn't contemplating a flat
Fixed about,
rate.
a flat fixed about.
Exactly. It's not contemplating a flat rate of trafficking support on top of Section 95 support. It's contemplating a rate of trafficking support that will vary depending on the amount of Section 95 support. And the Section 95 amount will vary according to, as I've shown my lords, 1, the form of asylum accommodation, 2, any other source of income, and 3, any exceptional needs. That's Section 95. Could I say something please, about Section 98? As the court's already heard, that's temporary support, pending a decision on whether the individual is eligible under Section 95. As I said a moment ago, Regulation 10 of the Asylum Support Regulations doesn't apply to Section 98 support. there is no general rule sum applicable to Section 98 support. The amount of any Section 98 financial support is discretionary. It's not bounded by any legislation. How does it work in practice? Ms. Giovanetti repeatedly said, well, in practice, it was accommodation, support in kind, and nothing else. We've actually got evidence from the Secretary of State in the bundle, which explains the position. It's in the supplementary bundle of documents. And if we could look, please, at page 219. This is a witness statement made by Simon Bentley, who, if one looks over leaf at page 220, paragraph 1, we see that at the time the statement was made, at least, he was the Home Office policy lead for asylum support. And at paragraph 4 on page 220, he explains that asylum support is provided under Section 98, where the person appears to be destitute, whilst the defendant is deciding whether they're eligible under Section 95. And then if we look, please, over leaf, page 221, paragraph 9, first 3 lines, for as long as the person remains in initial accommodation, support to cover their other essential living needs is provided by the accommodation provider in the form of full board in kind provision, cash or vouchers, or a mixture of both. So it depends. And then if we could skip forward, please, to page 223. Could I please ask my lords to read the whole of paragraphs 21 and 22? And so one sees the final 2 lines of 22, that even under Section 98, at least in Serco hotels, men got a cash payment of £5, women a cash payment of £10 a week. So the rate of payment under Section 98 in practice varies depending on circumstances. And when paragraph 15.37 of the guidance refers to financial support under Section 98, we say it must be taken to refer to the discretionary variable amount of cash that's paid or is payable under 98. Finally, then, could I say, please, something about Section 4? That, as the court has heard, is the support that's available for failed asylum seekers, people who have had their asylum claims determined and rejected. Section 4 and the regulations made under Section 4 don't prescribe any amount of financial support, in the same way as Section 98 doesn't prescribe an amount of financial support. But the practical position was, again, neatly set out in authority. And if I could show my lords the case of Mensa, which is in the supplementary authorities bundle. tab 5, page 142. And if within that authority we could please look at page 149. Paragraph 24, we see what the issue in the case was. The issue was whether it was lawful for a local authority to calculate Children Act support by reference to levels of Section 4 support. And so, to answer that question, Mr. Justice Lewis, as he was, said that he needed to examine the Section 4 regime, and that's what he then did.
Which paragraph?
So paragraph 24, he explains what the issue is. Paragraph 25, he says, in considering those issues, it's necessary to consider ... 2, the arrangements by which the Secretary of State provides support for asylum seekers and for failed asylum seekers. So that's the issue and how the judge addresses it. And then page 153, we get the summary of the Section 4 regime at paragraph 38. And if I could please ask the court to read paragraph 38. So the upshot of paragraph 38 is that you get less under Section 4 than you do under 95. And then paragraph 40, at the time of this judgment, the Section 4 amount, the value of the Section 4 support, was £35.39 a week. That was, as set out in the note that we put in on Monday of this week, that was still the position in March 2020, when the guidance was promulgated. And so when the guidance was, at the time the guidance was promulgated, you had a Section 4 amount, which was £35.39, as compared to the Section 95 amount, the general rule amount, which was £37.75. So, if I could please draw together the threads of my points about sections 4, 95 and 98. If we could please go back to paragraph 15.37 of the guidance, the supplementary bundle, tab 1, page 8. The second sentence of 15.37 begins in these circumstances. The circumstances being referred to are a victim receiving financial support under sections 4, 95 or 98. And those circumstances include a range of different levels of financial support. The amount under section 95 is liable to be different from the amount under section 4 and under section 98. And the amount under section 95 will vary depending on the individual's circumstances. And so when the second sentence provides for a total of £65 made up of asylum support payments and a further VCC payment, it's providing for a VCC payment that will vary according to the amount of the asylum payment. That was my first topic. Second topic, what are the consequences of that? They're pretty obvious. On a plain reading of 15.37, some victims will do better financially than others under the VCC. And just to give my lords, to carry that through, at the time the policy was promulgated, March 2020, a victim who was an asylum seeker on Section 95 support got a smaller VCC payment, was entitled to a smaller VCC payment than a victim who was a failed asylum seeker on Section 4 support. Because the Section 4 sum is smaller than Section 95 sum, you plug that into 15.37, that means a bigger VCC sum for the Section 4 failed asylum seeker than for the Section 95 asylum seeker.
Just pause there, Mr. Butler. You've got all this at your fingertips, and I hadn't. So, in March 2020, a victim or potential victim of trafficking who was an asylum seeker with a pending claim
Yes.
is therefore being dealt with under Section 98.
No. 95.
95. Right.
And let's assume that he gets the general rule sum. At the time the policy was promulgated, that was £37.75.
So the VCCs vary,
Exactly.
but the total payment doesn't.
No.
And that's driven by the architecture of the three sections you've taken us to.
Exactly. And the point I'm coming to, where I'm going to end up, is that all of this is anomalous. It doesn't make any sense. But that's a characteristic of this part of the policy. It's a dog's dinner. And the solution isn't to try and read out the single anomaly that we're concerned with in our case. The solution was to change the policy, as happened.
Can you just complete the comparison?
To complete the
Whereas
comparison,
a PVT whose asylum claim was rejected would then get what?
they got, under Section 4, 35.39. £35.39. And so, by way of VCC payment, they would get £65 less £35.39. What that means is they get £2.36 a week more by way of VCC payment than the Section 95 person.
And the fact that the claim to asylum had failed would not necessarily mean that the claim to be a victim of trafficking would be rejected.
No, it might be completely irrelevant for the reasons that my learned friend pointed out. The person might have been persecuted in the country of origin so as to found an asylum claim, or not, if they failed, and might completely independently have been trafficked en route or within the UK so as to make them a victim of trafficking.
Thank you.
So I was at this point just comparing Section 95 and Section 4. Another example of an anomaly under this paragraph is a victim who received higher Section 95 financial support on account of exceptional needs. So they don't get £37.75, they get something more because they've got exceptional needs. The effect of 15.37 is that they would get a smaller VCC payment than a victim without exceptional needs.
Yes. Could someone shut the door to the lobby, if they'd be so kind? Yes, carry on, Mr. Butler.
the next anomaly, a victim who received less Section 95 financial support on account of some third-party income would get a bigger VCC payment than a victim who didn't receive that third-party income. And then finally, the situation we're concerned with, a victim who received less Section 95 financial support because he was in fully catered accommodation would be entitled to a bigger VCC component than a victim who received more Section 95 support because he was in self-catered accommodation. Now, I accept that all of those examples may properly be described as anomalous features of a policy, of this policy. And there was another anomaly. If my lords please look at 15.36. A victim accommodated in self-catered accommodation provided under the VCC, so that's bullet 1, they get £65 a week. Self-catered VCC, £65 a week. Compare that to the third bullet. If you're a victim accommodated in self-catered accommodation from some other source, so suppose a charity provides you with self-catered accommodation, well, you only get £35 a week. Both self-catered accommodation, £30 difference. Again, no obvious logic for that anomaly. And then the final, even bigger anomaly, relates to setting off. So we've seen in 15.37 that there's a set off in respect of state asylum support. But by contrast, there is no provision in the policy for the set off of other kinds of state financial support. And what that means is that victims in receipt of mainstream benefits, like universal credit, they still receive the full amount of VCC support without any set-off. And so to work that through, practically, when this policy was promulgated, universal credit was worth about £94 a week, the basic level of it. A victim in self-catered VCC accommodation, 15.36 first bullet, would get £65 a week under the VCC, plus the £94 a week universal credit without set-off. By contrast, a victim in receipt of asylum payments would have them set off against VCC payments, 15.37. Now, could I do, on that point, could I just show the court what was said about that by the Court of Appeal in the case of MD? That's tab 21 of the main authorities. And if we could please look at page 513. Part of the judgment of Lord Justice Underhill, paragraph 64. The judge says, much of the argument before the judge and before us was about the Secretary of State's explanation of the other disadvantage, that is that unlike victims of trafficking group 3, and then he explains who group 3 is, that is those who receive PVOT support, and mainstream benefits. That's who Group 3 was. So unlike that group, the claimants receive only VOT and asylum seeker support. It was her case, the Secretary of State's case, that it was never the government's intention that victims of trafficking in Group 3, so victims in receipt of mainstream benefits, should be paid twice in respect of the same needs. That was a mistake or anomaly which gave the recipients a windfall. So the Secretary of State's case was that the lack of set-off in this policy for mainstream benefits was a mistake or an anomaly. And I'll just emphasise that it was never suggested by the Secretary of State, by the High Court, or by the Court of Appeal in MD that the policy should be interpreted so as to read out that anomaly. Instead, the Secretary of State applied the ordinary meaning, ordinary reading of the policy, and paid the full amount of VCC support to those in receipt of mainstream benefits, even though that was anomalous. So that's the end of my second topic, the various anomalies that arise from 15.37 and indeed 15.36. And then I ask the question, my third topic, what's the right approach to construing a policy of this kind, one that contains these kinds of anomalies? And could I just begin by emphasising the points of agreement? We accept the bullet points that are set out at paragraph 42 of the Secretary of State skeleton, which identifies points of the appropriate approach to construction. We also agree with the point that's made at paragraph 45 of the Secretary of State skeleton, that is that one can look at the temporal context in which the policy was drafted. But could I emphasise one point, which is the ordinary and reasonable reader approach to construction? And could I do that by showing the court a few passages from the case of Ricey? That's in the main authorities bundle at tab 7, beginning at page 104. This was a case that concerned a compensation scheme for people who had been wrongfully detained.
I'm just tracking this. You've given us a lot of quotes and references in your paragraph 53 onwards in the skeleton argument. I don't want to derail you, but is that a useful aid memoir for us as to where these points are going? Or perhaps when you're taking us to authorities, you could just link it in with the skeleton argument as you go.
Yes.
Okay, I have it at page 87.
Yes, the point that I'm now going to try and unpack a little bit is the point that's made at 53.2
Yes.
of the skeleton. So it's a case about a compensation scheme for wrongful detention. And if we could look, please, at page 138. This is Lord Justice Hooper giving the judgment of the court. Paragraph 123 he says, we've reached the conclusion that in re McFarland doesn't prevent this court from deciding what the policy means. There'd been some debate about that in the divisional court. To that extent, we disagree with the divisional court. We shall use the XP Web text whilst accepting that it could be worded in a more modern way. Now, the XP Web text is set out earlier in the judgment at page 134. Paragraph 108, where Lord Justice Hooper says that in the case of Daguerre, I said, quote, it's agreed that the appropriate test for interpretation is to be found in a passage of the judgment of Lord Justice Lawton in XP Web. And then overleaf, top of page 135, second line of that citation, this entails the court deciding what would be a reasonable and literate man's understanding of the circumstances in which he could, under the scheme, be paid compensation for personal injury caused by a crime of violence. So that is the XP Web test that was then adopted by the Court of Appeal in Ricey. And one then sees the application of that test at page 139. Paragraph 125, third line, the court asks what a reasonable and literate person would make of the policy. And then the third line from the bottom of that paragraph, what would the ordinary and reasonable reader of the scheme think?
The minister or his civil servants can't come along later and say, this is what I meant to say, or this is what I think it means.
Humpty Dumpty.
Or this is what I wish I'd said.
Yeah, this is what I wish I'd said.
Yes.
This is a, yes.
And
I don't think Ms. Giovannetti was really relying on that sort of generation of authorities has passed.
I'm not suggesting she was. I wanted to emphasise the ordinary and reasonable reader test, and in a moment I'm going to explain. I'm going to try and bolster that. But just to pick up the point.
Humpty Dumpty. That's a reference to what Lord Reed said.
That's a reference to what Lord Reed said in Tesco stores, and in Tesco stores, the Supreme Court cites Ricey as good authority. So it's got the highest level of backing. The point I was going to go on to make is that one can understand why policies have to be interpreted in that way when one considers the function and the legal effect of policies. And I think I'm really picking up a point that the court made this morning. Those to whom a policy applies have a public law right to be treated in line with the policy. Now, that used to be understood as an application of the doctrine of legitimate expectation, but it's now understood as a freestanding public law right. It's set out by the Supreme Court in Mandalia, which you've got in the authorities bundle, but I don't think I probably need to show you that. And to avail himself of that public law right, an individual needs to be able to understand what the policy says and means. And there are two illustrations of that in the supplementary authorities bundle. Again, I'm not proposing to turn them up unless you want me to, but there's the case of Telios, in which the Court of Appeal says, well, look, taxpayers need to know what the revenue's tax policy is so that they can assert their rights. And the very well-known case of Lumber, immigration detainees need to know what the Secretary of State's detention policy is so that they know when they're entitled to be released. Unless a policy is interpreted according to the ordinary and reasonable reader, then the individual who's affected by the policy can't avail himself of the right to be treated in accordance with it. In this case, if 15.37 means what the Secretary of State contends it means, I ask rhetorically, how on earth was JB supposed to work out his rights under the policy?
Do you rely on supporting that, the victim care contract and the Salvation Army frequently asked questions document, sorry, the document issued to the Salvation Army?
I do. I say that the context bolsters the ordinary reading of 15.37, and I'm going to deal with the context as my fourth topic, if I may.
Yes.
But that still leaves us with the problem of what do you do about the anomalies in the policy? How does one approach those? So, for example, someone who receives more Section 95 money on account of exceptional needs receives less VCC money. Now, the Secretary of State's argument is that the court can and should correct the policy relying on INCO. And could I just turn that up so that I can make my submissions on the effect of it? It's Main Authorities Bundle, tab 5. And if we could look, please, at page 87. Letter E, the power is confined to plain cases of drafting mistakes. And then letter F, before interpreting a statute in this way, and I accept that the same approach can legitimately be taken to policies as in relation to statute. Before interpreting a statute in this way, the court must be abundantly sure of three matters, and those are then set out. Now, in my submission, what's clear from the INCO principles is that it's not enough to identify that the instrument produces anomalous results. And I make two particular points as to why the INCO principles can't be applied here. The first point is that the anomalous results have to have been the result of a drafting slip, letter E.
Your paragraph 62. The IMCO argument wasn't run below.
No.
The IMCO, in fact, comes along after the arguments. I can be treated as if I was a Category 1 person, or I don't appear at all, I'm a lacuna. That was the case below. INCO has just arrived here.
Yes.
Yes.
I don't take a point about the lateness, the point at which the argument is raised. I just say it's a bad argument for the reasons that I'm about to set out. The point I'm making at the moment is that the power to correct, if one puts it that way, is limited to plain cases of drafting mistakes. Now, my submission is that a flaw in the design of a policy isn't the same thing as a drafting slip.
A drafting slip is something like using the word by instead of from.
Exactly, and that's a rather good example. So, by way of example, it's anomalous. The Secretary of State accepted it was anomalous. The Court of Appeal accepted in MD it was anomalous. that universal credit isn't set off against VCC support. But that's a flaw in the design of the policy. It's not a drafting slip. And by the same token, in relation to 15.37, the anomalous results that I've set out from the various legislative permutations, those aren't the result of a simple drafting slip. They appear to be the result of a failure to engage how sections 4, 95 and 98 operate. It's a much more fundamental problem than a slip of the pen.
And you would be entitled to say that if the court is entitled to iron this part of the policy in order to make it level for everybody, there's nothing on that principle to stop it having to iron the whole thing.
Well,
To remove every crease.
where does it end? Because I've identified, we're talking in this case about a single anomaly. We're talking about the full board accommodation anomaly. But as I sought to set out earlier in my submissions, that's only one example of a number of anomalies that result from 15.37 and other parts of the policy. And absolutely, if the court interferes with this bit of 15.37, then why not go on and correct every anomaly in the policy? Why not rewrite it?
Mr. Tam, leading counsel for the Home Office, I think in the Court of Appeal case, used the phrase that the squidgy jelly, although the Court of Appeal didn't much like it. But,
no, I wasn't very
I can see the point he was making, that you push in one bit of jelly and a bit comes out the other end.
Well, that's why the solution is to remake the policy. It's a policy decision, not a drafting decision. And that, I think, leads into the second point I was going to make in relation to the INCO principles, which is that, as we see from the third principle, just by letter G, it has to be clear what the policy choice would have been if the anomalous results had been confronted. And could I just illustrate why it absolutely isn't clear what the policy choice would have been if the policymaker had confronted these anomalies in March 2020? I've shown the court that a person with Section 4 support was, on a plain reading of 15.37, entitled to a VCC top-up payment of £29.61. That's £65 minus the Section 4 payment. So Section 4 person, £29.61. Whereas a person with Section 95, general rule, Regulation 10.2, general rule support, would have been entitled to a VCC payment of £27.25. That is £65 minus the £37.75 figure. So if one just takes this as an example, one's got those two figures that result from 15.37 depending on one's circumstances. What policy choice would have been made if that anomaly had been confronted? Well, the policymaker could have decided that the policy should provide for a flat rate payment of £29.61, the figure that the Section 4 person got. Or the policymaker could have decided that it should be a flat rate of £27.25, the rate that the Section 95 general rule person would have got. Or the policymaker could have alighted on some different amount, or taken some different approach entirely, and not approached it on a flat rate basis. It was a policy choice.
So the submission that an INCO type approach is really most likely to be found in a case where there's a binary choice to be made in leaving as it is or substituting it with some obvious alternative.
Where it's clear what the result would have been but for the drafting slip. And my point here is, one, no drafting slip. It's a fundamental policy problem. Second, even if you were to characterise this as a drafting slip, you don't know what the result would have been but for that slip.
Ms. Giovanetti focused on what she said was the anomalous distinction between somebody in full board Salvation Army accommodation, £35 a week, somebody in full board NASS, VCC, Home Office accommodation, £65 a week.
It's an anomaly.
Yes.
It's not logical. In the same way as a whole load of the results of 15.37 and 15.36 are not logical and result in anomalies. But it's not something that can be fixed through the INCO approach. Now, I accept that a policy choice was made in August 2020 after this claim was brought and the problem was identified. And the policy choice in August 2020 was to amend the policy to provide a flat rate payment of £25.40. But my simple point is that that wasn't the only policy choice available in March 2020. And for the court to speculate what the policy choice would have been would be to cross the line between the separation of powers and to do what Lord Nichols said is impermissible at letter E. So for those reasons we say that not a case of drafting mistake, but even if it was, the third INCO principle isn't satisfied. So if you can't correct this kind of anomaly through the slip rule, what's the solution? We say there are two solutions. The first solution stems from the fact that a policy isn't law. It has legal consequences, but it's not law. And a decision maker is free to depart from policy if she identifies a good reason for doing so in the course of the decision-making process. Well-established public law principle.
It's got nothing to do with the case, but strictly speaking, the policy can be law, can it? Can it not? For example, something like the immigration rules.
Well, that's
treated as law.
That is the exception that proves the rule, as it were. It's regarded as a hybrid. The immigration rules are a hybrid because they are subject to parliamentary scrutiny and approval in a way that normal policies aren't. So when I say that a policy isn't law, I'm talking about ordinary policies that aren't subject to parliamentary approval.
No, I don't want to.
No, there's some
leads
discussion.
us into deep philosophical waters.
Yeah,
leave that for another case.
I don't think I need to go there. I mean, there's a discussion of the status of policies by the Supreme Court in a case called A against the Secretary of State that was decided last year, and I think it was Lord Sales that he uses the expression "a policy isn't law," nothing turns on that. The point I'm seeking to make is that a decision maker is free to depart from the policy if a good reason for doing so is identified. And that is a safety valve. So the Secretary of State could have said, didn't say, but could have said, the accommodation of so many victims in full board accommodation during the pandemic was unprecedented, and we're therefore not going to, we've made a conscious decision not to follow paragraph 15.37 in your case, Mr. JP. Now, I'm not making a concession that that necessarily would have passed muster as a good reason to depart from policy, but I'm just illustrating how this safety valve could in principle work.
Well, you're using depart from in the sense of in an individual case.
Yes.
As opposed to amending it.
Exactly.
If after, of course there was a lot going on, to put it mildly, in March and April 2020, but if after 5 weeks rather than 5 months, the decision makers had said, there may only be 63 of these cases, but it's 63 too many and we're going to amend the policy, that they could, on the face of it, have done that.
Well, that's the second.
That's your second
my
option.
second point. It's my second point. I mean, it's the cleaner way of doing it.
That's amend rather than depart from.
Right, amend rather than
individual
depart.
Case.
At the moment, I'm just
Yes.
dealing with the power to depart from policy.
There is a power to depart from policy.
There's a power to depart from
It's
policy.
fraught with danger, though, isn't it?
It's fraught with danger because if you do it in too many cases, it might be said you're operating a secret policy which undercuts the published policy, which is unlawful, as we know from Lumber. But as long as you do it on an individualised basis and you've got a good reason for doing it so, you're permitted to depart from policy.
But the neater thing to do is amend the policy.
The next thing to do is amend the policy, but could I just work through that first safety valve to finish the points? I just wanted to make clear that that's not what the Secretary of State said here. Her case is based solely on the proper interpretation of 15.37. She appeals against the declaration the judge made as to the proper interpretation of 15.37. Could I just illustrate this by the case of Mandalia? It's tab 13 of the main authorities. Page 270.
This is Lord Wilson, isn't it?
It is. And so on page 270, paragraph 31, Lord Wilson says that in his judgment in Lumber, Lord Dyson had articulated 2 qualifications to the obligation to follow published policy. He'd said at paragraph 21, it's well-established principle of public law that a policy shouldn't be so rigid as to amount to a fetter on the discretion of decision makers, but there was ample flexibility in the process instruction. So Lord Wilson is here talking about the process instruction in issue in Mandalia, to save it from amounting to a fetter on the discretion of the caseworkers. Lord Wilson had also said the decision maker must follow his published policy unless there are good reasons for not doing so. But the Secretary of State doesn't argue that there were good reasons for not following the process instruction in the case of Mr. Mandalia. Her argument is instead that, properly interpreted, the process instruction didn't require the caseworker to alert Mr. Mandalia to the deficit in his evidence before refusing his application. So the search is for the proper interpretation of the process instruction, no more and no less. So that's this case. We're only concerned with the proper interpretation of the policy. But the point I've been seeking to make is that the Secretary of State isn't helpless when confronted with anomalies. There's a power to depart from policy for good reason. He just chose not to take that route here. So that's the first potential solution to anomalies of the kind that we face in this case. The second
that deals with it's not going to happen now. No, it's not going to happen now. The next one is it's not going to happen in future. Changing the policy.
Exactly. And the point is that unlike legislation, the Secretary of State is free to change her policies as and when she sees fit. And as we saw, she did in response to this claim. So if a policy is found to have undesirable consequences, there's no need to distort the language of it to fit the situation that hadn't been contemplated. You can simply amend. And indeed, that's crystal clear when one looks at the statutory duty to make this policy. If we look at the main authorities bundle, tab 3, page 61. So this is the duty to make the statutory guidance. Subsection 1, the
Must issue
guidance.
may from time to time revised.
Exactly. Subsection 2, may from time to time revised. That was the solution. So that's my third topic, approach to construction. Can I then finally deal with the context?
I mean, your submission about this, presumably, is that it's not good for the law and it's not good for governance that issued policies are then not followed if they can be efficiently changed, and that as a general approach, one shouldn't reach strained interpretations in order to rescue policy that is not having the effect intended.
Yes.
It's fairer to amend than to pick up individual cases, isn't it?
Absolutely. Well, I'd go so far as to say it's inimical to the rule of law to distort the ordinary meaning of policies so as to deal with unforeseen situations.
Well, it doesn't, for example, drive good policy drafting.
It doesn't.
If people who draft policies can have some comfort that what they think they mean is going to be found, even if they don't say it, that, as you say, is not a good direction to be moving in.
Yes, well, absolutely. That's a good governance point. But there's also a rule of law point, which is that individuals have public law rights under policies, and those public law rights will be rendered nugatory if the rug can be pulled out from underneath their feet.
It's a danger with a policy structured approach as opposed to a law structured approach.
Yes, yes, yes. I think
we don't need to go
no.
that further. That's an yeah.
So, fourth topic, the context in which the March 2020 policy was made. This is really just a bolstering submission. So I've accepted that the Secretary of State's point that the policy can be interpreted in context, including what she calls the temporal context. And I propose to make 4 contextual points. The first point is that the 2020 policy adopted the arrangement that was set out in the 2015 victim care contract. And indeed, we've seen from paragraph 15.37 that it refers to VCC support. Well, VCC means victim care contract, which means the 2015 contract. And if you need it, we've got in the page 6 of the supplementary authorities, we've got the glossary from the 2020 policy. Tab 1, page 6. Victim care contract refers to the Home Office contract to provide care to adult victims of modern slavery in England and Wales.
Yes.
That's the 2015 contract between the Home Office and the Salvation Army. So that's the first point. The second point is that the Secretary of State doesn't know why the 2015 contract was drafted as it was. And we see that in the supplementary bundle at page 193. This is a witness statement of Johnnet Tan filed in the MD proceedings that introduced into these proceedings under cover of another witness statement. And she explains at paragraph 2 that at that stage at least she was responsible for adult victim support policy. And if we look please at page 196, paragraph 12, victim support policy was inherited from the Ministry of Justice in 2014. And then she goes on in paragraph 12 to make the point that it's, the policy reflected the contract. And then paragraph 13, the rationale for the rates originally set out in the contract isn't clear, as we don't know what the policy intention was at the time from contemporaneous documentation or corporate memory. So they don't know why the 2015 contract was drafted as it was.
Not that long ago, is it?
Sorry?
It's not that long ago.
Not that long ago. But there we are. That's my second contextual point. And then my third contextual point is that in November 2018, Mr. Justice Mostyn gave a judgment in which he interpreted the asylum set-off provisions in the contract. So that was 2 years before the statutory guidance was produced. He was interpreting the contract. And if we could look at that, please, it's in the main authorities bundle at tab 16. And if we could look, please, at page 408. At paragraph 9, the judge points out that the contract was executed on the 1st of April 2015, 3 lines at the bottom of that paragraph. And then paragraphs 11 and 12, he sets out the relevant provisions of the contract, which you've already looked at in their original form. Paragraph 13, line 3, he points out the grammatical error, which, as I've already said, we say is a legitimate use of the slip rule. Paragraph 14, at the end of line 2, he says that in the third class, so that's the third class in the box above, in the third class, the victim must give credit for any money received by him or her under Section 95 of the Asylum, Support and Immigration Act and the regulation. Now he then goes on to say what the set-off based on the general rule was as at 2018, when this judgment was given. But could I just make a point about the position when the contract was executed? We've set these figures out in the note that we filed on Monday. If you look at page 2 of that note, the first box in our table, we've set out the rates as at the 1st of April 2015. That's the date on which the contract was executed. And if you look at the Section 95 support general rule figure, as at the 1st of April 2015, one can see that there are 2 different rates. If you were aged between 18 and 25, you got 36.62 a week. If you were aged over 25, you got 42.62. So the consequence would have been that the VCC payment would have been lower for victims aged over 25 than for those aged 18 to 25. So that's yet another anomaly, but one that arose from the contract rather than from the policy. Paragraph 15 one sees that the Secretary of State was arguing that the set-off provision in the contract was a mistake. I could just ask you to read 15.
In Mr. Justice Mostyn.
Exactly.
Yes.
And then Mr. Justice Mostyn rejected that submission at paragraph 16. But what's significant is his analysis when he rejects the submission. If one looks 10 lines down, which is just about where the first hole punch is in my bundle, he says, assume, halfway through the line, assume that there was an abatement of the asylum money to £10.50 in the way that Mr. Sheldon for the Secretary of State had suggested. The victim then goes back to the Salvation Army and asks for his or her entitlement under the contract to be increased to £54.50 to reach the headline figure of £65. That's then disclosed to the Asylum Authority, which eliminates the asylum money altogether. The victim then goes back to the Salvation Army to get the full amount of £65, as no asylum money is now being paid. So that was Mr. Justice Mostyn's reasoning for rejecting the Secretary of State's submission. But what's significant in my submission is that that's akin to how we say paragraph 15.37 works, in that if you reduce the asylum payment, then the VCC payment goes up accordingly. So the point, perhaps not surprising, but the point I'm making at this stage of my submissions is that Mr. Justice Mostyn understood the contract to operate in the way that we contend the policy operates. And then my final point on this judgment, if we could look please at page 412. Now, earlier on in this judgment, the judge had been very critical of the Secretary, as he saw it, the Secretary of State's breach of duty in not having by this stage published statutory guidance under section 49. And in paragraph 31, he says, no doubt account will be taken of this judgment when the overhaul announced in Parliament on the 26th of October 2017 is formulated and implemented next March, as well as in the long overdue guidance to be given under section 49 of the 2015 Act. So in other words, I've told you how the contract works, you've misunderstood it, take that into account when you draft the guidance. That then takes me to my fourth and final contextual point, which is that the Secretary of State didn't appeal Mr. Justice Mostyn's decision, but instead adopted Mr. Justice Mostyn's interpretation of the contract. And one sees that the Secretary of State adopted Mr. Justice Mostyn's interpretation of the contract in the FAQ document. That's in the supplementary bundle. I've already looked at it. Page 298.
$298.
298. So before I get to the actual FAQs, I wanted to show you the covering letter. So one can see that it's from the head of the victim care contract, as it's put on page 299. It's directed to the contractors, and it's sent on the 29th of January 2020. So just under 2 months before the statutory guidance was promulgated. It tells the contractors how much they should be paying under the contract. And the point I make is that it represents the Home Office's understanding of the contract immediately before the contract was carried into the statutory guidance. And if I could then go to the memo that accompanied the letter, you've already looked at this, page 305. And as Ms. Giovanetti pointed out, we say that it's number 4 that applied to somebody in the claimant's position. And that would have been clear to somebody operating under the contract, because outreach support is a defined term under the contract, and it would make it clear that this is support to provided to somebody who's in asylum accommodation.
Could you give us that cross?
Page, let me just check it before I give it to you.
Yes.
Core bundle, page 242. This is the definitions section of the 2015 contract. Final entry on page 242, outreach services means the services provided to service users who aren't accommodated by the contractor. So an outreach NAS client is somebody who's supported by NAS and not accommodated by the contractor. So in my submission, actually, FAQ number 4 is pretty clear in its meaning. And it chimes with Mr. Justice Mostyn's construction of the 2015 contract. So if I draw the threads, if I may just draw the threads together of my contextual points, Mr. Justice Mostyn explained how set-off worked under the contract. The Secretary of State accepted that interpretation of the contract. The Secretary of State then carried that approach into the policy. And that context, in my submission, strongly supports the ordinary reading of 15.37. And so, just to finish off my submissions, if I could ask the court to turn up the declaration that the judge made below. This is in the core bundle at page 99. We say that that declaration is unimpeachable. The policy meant what it said. Yes, it contained a whole load of anomalies, but the solution was to amend the policy, just as the Secretary of State did in August 2020 when the problem was drawn to her attention. And can I just deal very briefly with the Floodgates argument, if that's the point that my learned friend was making? Clearly there's no Floodgates issue with the 60 or so people who were in JB's position, but I think it was being suggested that, well, if you don't allow the appeal, then that may give rise to a difference in treatment and there'll be a discrimination claim brought by other people on the back of this case. Well, that concern is assuaged by the Court of Appeal's judgment in MD. Because what happened in MD was that there was the mistaken, as it was put, overpayment of VCC support to those in receipt of mainstream benefits. And what the Court of Appeal said is that did not justify making an equivalent overpayment to those not in receipt of mainstream benefits. So there's simply no floodgates concern.
So what are we left with then? What's this claim nationally worth to your client?
We think it's worth about £500.
It's getting a bit silly, this. We have 63.
Yes.
Maximum. So about £30,000 this is all about.
And of course the costs of...
Yes, I don't think we've had costs statements yet.
Well, you won't get them from us because it's a legally aided case.
Yeah.
But I can
Anyway,
say
you don't choose to be here.
We don't choose to be here.
You went to the administrative court, and yes, all right. Thank you.
Well, just to finish that point, I mean, it's obvious from our side that the costs of this appeal will dwarf the cost consequences for the Secretary of State if the appeal is dismissed. So just one more point, if I may. Miss Christie reminds me, and is explained in Mr. Ryder's witness statement, that it doesn't affect anything in the appeal, but just so the court knows, the Secretary of State says that she's overhauling the entire support policy, so that financial support will no longer be provided on a blanket basis, but will be based on an assessment of individual need. So you will end up with a VCC payment that entirely reflects your own personal circumstances. Doesn't affect anything, but so that the court knows.
Yeah.
Unless I can assist further, those are my submissions.
No, thank you.
Thank you very much, Ms. Christie. Right, Ms. Giovannetti.
I don't think I've got anything to say in reply, my lords, unless there's anything particular to address.
Thank you. Well, we're very grateful to all of you. This was beautifully presented, orally and in writing. Wish it was always so. But we will, of course, reserve judgment. We'll let you have it as soon as possible. I'm sure everybody in this court knows what I'm still supposed to say. It will be sent out under the usual embargo. I hope that by now each side has supplied my clerk with the email addresses to which the draft should be sent. And that will be, of course, for pointing out typos and obvious errors like putting by when you mean from and so on, and not for re-arguing the case. Thank you very much for your assistance.
All rise.